Thank you.
Okay, all right. So I think we're ready to go then. Just for the benefit of the public, if there are members of the public watching, this is an application for an extension of time for the commencement of discipline proceedings against 3 officers. The application for the extension of time is brought by the Thunder Bay Police Services. I was appointed by the Superior Court of Justice in Ontario to stand in the shoes of the Thunder Bay Police Services Board. So I am performing the duties and responsibilities of that board today. And before we start, I just want to read one thing to the public. The counsel involved and the clients involved are aware of this, but the Thunder Bay Police Services Board has ordered a prohibition on any further publication of the names of or any identification or any identifying information relating to any officers named in the Oiprd investigative report or in any other documents or reports filed on this extension application. Any information that could identify any officers shall not be published, broadcast, or transmitted in any way. And I stress that that refers not only to the 3 officers against whom the proceedings are sought, but it's any officer named in any of those documents. So we now will hear from counsel, and perhaps before hearing from Ms. Walburn, who will begin, I can tell you that Ms. Walburn appears for the Thunder Bay Police Services, Ms. Stevenson Welsh, and Ms., I hope I get this right, Saxnager, apologize if I'm wrong, appear for the OIPRD. Mr. Faulkner, Julian Faulkner, and Molly Churchill appear for the complainants. Joanne Mulcahy appears for the respondent officers. So I think we're ready to proceed. So I'll call on Ms. Walburn.
If I may, Mr. Ferrier, I just wanted to introduce Mr. DeBungee, who's behind me. Brad DeBungee, a member of the DeBungee family in the First Nation complainant, and my colleague at my side from the Thunder Bay office is Natalie Osla. I just wanted.
Okay. Well, good afternoon, and good afternoon, especially Mr. Bungee. Thank you.
Thank you.
All right. Yes, Ms. Walburn.
Thank you. As indicated previously, my submissions will be relatively brief on behalf of the Chief of Police for the Thunder Bay Police Service. This is going back quite some time. This is an extension application that was originally filed on March 8th, 2018. And that's pursuant to Section 8317 of the Police Services Act, which outlines that the Chief of Police is legislatively required to bring this application when the period of investigation for a Police Services Act charge goes beyond 6 months. That is found specifically, just for your reference, Section 83 sub 18A2 is the clause that applies here. So if 6 months has elapsed since the day described, then the board must determine whether or not that the delay in serving the notice of hearing was reasonable. The date or the 6 months begins to run. In this case, it's the day on which the complaint was retained by the independent police review director. So in that case, the date that would be prudent here to mention is April 22nd, 2016 was the date of retention of this complaint by the Office of the Independent Police Review Director. The Chief of Police takes no position on the period of that delay, So that delay, sorry, I'll back up, runs from April 22nd, 2016. The investigative report, the findings of the Independent Police Review Director were given to the service on February 15th, 2018. At that time, that is why this extension application was prepared and filed. Then at that time, the chief did take a position and indicated that the delay was reasonable. Subsequent to that, there has been many court proceedings that have gone on, not on the facts of this case, but that stem from issues that came up with respect to this case. That brings us to today, another 3-year delay. It is worth noting, however, and I will make no submissions on that initial 2-year delay period. I believe that the Oiprd Counsel will be speaking to that, as the complaint was retained by them, and so they can speak to the delay in why it took 2 years rather than the 6 months to complete the investigation. I will note, however, that the 6 months found in the Police Services Act is not a limitation period per se, as you would find one in courts. So this essentially, and a book of authorities was produced back in 2018 that I believe that you have the benefit of having, which simply indicates, and I will just briefly, very, very briefly do this. The limitation period is not, it doesn't require strict adherence. That's found in the case of Ackerman, which at your perusal is paragraph 21, which is tab 4 of the Book of Authorities. That's also found throughout the case of Forstall, which is at tab 6 in the Book of Authorities. And finally, in the case of Coombs at paragraph 7, which is at tab 5 of the Books of Authorities, it indicates that the board can grant, or an investigation into a charge can go over the 6 months if there's extenuating circumstances. And that's what the board needs to consider in looking at an extension application, is the causes for the delay as a whole in light of the circumstances. So the legislation and the case law doesn't parse it out by chief delay versus Oiprd delay. They indicate an overall holistic delay from the retention of the complaint to the end, to the service of the notice of hearing. That's specifically found at Oiprd in Niagara. It's paragraph 72, which is tab 3 of the Book of Authorities. The preceding 3-year delay that comes after the investigative report is given to the Thunder Bay Police Service, it's submitted, it's not attributable to the Chief of Police in the Thunder Bay Police Service. A court proceeding was commenced. The chief simply exercised her legal right to respond to those court proceedings. And it was at that time when those court proceedings began, specifically August 2nd, 2018, the Chief of Police filed an addendum to the extension application, switching the view to taking no position. So again, I won't comment on the specific delay. However, I think it's important to note, given all that's gone on in this particular case, the purpose of an extension application. I understand that there will be extensive submissions from other counsel, but I think it's important to focus on the reason for an extension application, which is to simply look at the reasonableness of the delay. It's not to get in or an adjudication of the merits of the allegations. The issue here, and the issue to be determined, is extremely narrow. It's whether or not the delay, taking into totality the circumstances surrounding the investigation, so this specific case, if that delay was reasonable. And that's it. The merits in which there's a proper evidentiary record will be determined at a hearing, if there is a hearing. Subject to your questions, those are my submissions.
Thank you. I have no further questions. Thank you, Ms. Walburn.
Thank you.
Ms. Stevenson Welch.
Hi, actually, my colleague Miriam will be making submissions on behalf of the Oiprd.
Okay, thank you. Ms. Sack, I'm sorry, could you tell me how to correctly pronounce your name?
Of course, it's Sack Schneider. Sack Schneider.
Sack Schneider. Thank you very much.
Yes.
Go ahead.
My pleasure. Good morning, good afternoon. Ms. Stevenson Welch and I are counsel on behalf of the director. I propose to make the submissions today, but Ms. Stevenson Welch, who's been with the file from the beginning, if there are any questions that are a little more factual, I may defer to her with your leave. What I propose to do in my submissions is speak a little bit about our office, just for some context, to explain the types of conduct complaints we do, and to talk a little bit about systemic reviews, because there was a concurrent systemic review in this matter, which is very much tied into our conduct investigation. I propose next to review Section 83(17) of the Police Services Act, to speak about the legislative purpose of that section, and to mention the factors that ought and ought not to be considered in my submission. And then I'll move on to the delay that was involved with our investigation of this complaint. And lastly, I'll speak a little bit to the public interest in having this matter proceed to a hearing, but I expect Mr. Falconer will have a little bit more to say on that, so I'll defer to him. So by way of background, our office came into existence in 2009, and we're a civilian oversight agency that oversees, manages, and on occasion investigates complaints into allegations of police misconduct. Prior to our existence, police services would manage their own complaints, including those from members of the public, but the Police Services Act gave us the authority to conduct those investigations where appropriate. And where we find a complaint that we believe ought to be investigated, such as this one, we have the ability to send it back to the police service that it came from, to send it to another police service, or to retain it ourselves. And in this instance, as your Honor is aware, we retained it ourselves. And when we do that, we really stand in the shoes of the chief of police for the purposes of the investigation, which is why Section 83(17) applies to our investigation. Once our investigation is concluded, the results are handed to the chief of police, which is why it's his or her obligation to bring the application pursuant to 83(17) when the 6-month period has been exceeded. Importantly, what we have that police services didn't have is the ability to conduct systemic reviews. And these are an incredibly important part of civilian oversight, because they go beyond the conduct of a specific officer in a specific instance. They really seek to identify and recommend changes about systemic issues that arise in policing. And on some occasions, this one in particular, as well as during the G20 that arose in Toronto, our office has conducted concurrent conduct complaints, so complaints about a particular officer's conduct in a situation, but also a broader systemic review about what gave rise to the complaint. So that's our general background of our office. In this matter, as Your Honor may be aware, we received the complaint from Mr. DeBungee and Chief Jim Leonard on March the 18th, 2016. And the complaint centered on the flawed investigation by the Thunder Bay Police Service into Mr. DeBungee's brother's drowning death in October of 2015. Appended to the complaint were submissions of counsel, and they identified the concerns not only about tunnel vision in the particular investigation involving Mr. DeBungee's brother, but also outlined how this was a broader issue in Thunder Bay with policing. The complaint outlined how the early determination by the Thunder Bay Police Service in this matter that there had been no foul play into Mr. DeBungee's death added to the community's crisis of confidence with respect to the police service's ability to thoroughly investigate the drownings of Indigenous people near or around Thunder Bay. Now, this is important too contextually, because at the time there was an inquest ongoing that had been ongoing for some time into the deaths of 7 First Nations youth in Thunder Bay. And that inquiry had also revealed, inquest rather, had also revealed that there were some premature determinations of no foul play in death investigations. So presented with this complaint and having reviewed it, the director determined that it was appropriate not only to retain the complaint for investigation, but also to conduct a concurrent systemic review. So the retained date, as Ms. Walborn had mentioned, was April 22nd, 2016. But at that same time, thought was given and a decision was made in and around that time that a systemic review would be conducted. And that announcement that we were to conduct one was made on November 3rd, 2016. And in announcing that review, Mr. McNeely, who was then the director, stated that alarming questions have been raised about the way the Thunder Bay Police Service investigates the disappearances and deaths of Indigenous people. Indigenous leaders and community members say that these investigations and other interactions with police devalue Indigenous lives, reflect differential treatment, and are based on racist attitudes and/or stereotypical preconceptions about the Indigenous community. The director felt it was critical that these issues be independently examined through a systemic review, which in turn would enable him to effectively address the issues and make meaningful recommendations. The conduct investigation and the systemic review proceeded largely side by side, in that when investigators were in Thunder Bay, they conducted interviews for both reviews, they gathered evidence, there was some evidence used on one applicable to the other. And the conduct investigation was completed first. It was completed on February the 15th of 2018. So approximately 22 months after the complaint had been retained. And there were two allegations of misconduct identified. The first was a neglect of duty. So our investigation identified 11 deficiencies in the manner in which members of the Thunder Bay Police Service investigated Mr. DeBungee's death. And this allegation relates to all three of the respondent officers. Additionally, there was a finding that the allegation of discreditable conduct was substantiating, meaning there were grounds to believe the misconduct had been committed, and that was for failing to treat Mr. DeBungee and his family equally and without discrimination on the basis of their Indigenous status. Some 10 months after our investigative report was released and these 8317 proceedings went underway, we released on December 12th, 2018, the systemic review. Now that matter, there were over 100 meetings that had been held with individuals, Indigenous organizations, First Nations leaders, and community members throughout the time. And the report found significant deficiencies in sudden death investigations involving Indigenous people that were due in part to racial stereotyping. The report also addressed systemic racism within the Thunder Bay Police Service more generally and found that it existed, that being systemic racism, at an institutional level. The outcome was 44 recommendations, including that the deaths of 9 Indigenous people be reinvestigated by a multidisciplinary team. Subsequently, Chief Hoff did create this multidisciplinary and multi-agency team to determine what investigative steps ought to be taken with respect to these 9 identified deaths. And this did not at the time include Mr. DeBungee's, although I understand that subsequently that was included. And I believe there was an announcement just last week that his death will in fact be reinvestigated. And so I think that I was hoping to demonstrate through that history that the matters were inextricably intertwined and they informed each other, both the conduct and the systemic. But because the conduct, and I'll return to that now, which is the focus of this application, because it took longer than 6 months to complete, the chief was required to bring this application. And I note, just pausing here, the chief did so quite expeditiously. From the time that we provided the report and our submissions on the application, I think it was a turnaround of a day or two, by which time on March the 7th, 2018, the chief had filed the application, or at least served it on the parties that may have been filed the day after. So what's to be considered in an 8317 application? And I think it's helpful to remember the purpose and the legislative intent and to keep that at the forefront of what this section is meant to do. As Your Honor is aware, the board is the employer of the chief, and they oversee the chief in many of his or her functions. including how the chief administers the public complaint system. So this application is an administrative process, and it's been held by numerous courts to be administrative in nature. The board exercises a statutory power of decision of an administrative nature in this application, and the purpose of which is to exercise a supervisory authority over the police and how the chief of police and how he or she handles complaints generally. And the purpose of this is to ensure that the board supervises how the chief administers the complaints to make sure investigative delays are not reasonable. And the reason for that is, on the one hand, with respect to police officers who are the subject of a disciplinary investigation, they ought not to have it hanging over their head or something akin to a sort of Damocles, where they can't continue with their careers or get promoted while charges are outstanding. But it's also to ensure that complaints by members of the public aren't swept under the rug, that they're not investigated or not reported on. And thirdly, I guess, it's also to ensure that the chief, or our agency, when we stand in the shoes of the chief, isn't grossly negligent in the manner in which the investigation proceeds. Now, if Your Honor is of the view that the application ought to be granted, then the notices of hearing are served on the officers, and there's a disciplinary tribunal that will be held. And I think it's important to bear in mind throughout this application that whatever the outcome of this application, if it is granted, for example, all of the arguments raised by the respondent officers about prejudice and other issues that have been raised, the respondent officers are in no way precluded from raising those arguments before the disciplinary tribunal. The hearing officer has the ability to stay proceedings for an abusive process. And if the respondent officers feel that the delay has been abusive, then they can seek to persuade the hearing officer of that. So I think it's important to note that this isn't, they do have a forum, and often in my submission, and I'll return to this, I think, is that really the tribunal is the appropriate forum. The hearing officer is the appropriate, before the hearing officer is the appropriate forum in which a lot of the concerns raised by the respondent officers are properly addressed. Okay. So moving then to what the time period ought to be for consideration. So I think it's all in agreement that the start date is April 22nd, 2016, but in my respectful submission, the end date to be considered is March the 8th, 2018, the date on which the chief brought this application. The post-investigative delay period, meaning the period from when the matter was first scheduled to be heard in April 2018 until today, is not a factor that ought to be considered, and it doesn't weigh into the analysis. And I say that for several reasons. First, again, the purpose of this section is to permit the board to supervise the chief of police or our office, or to ensure that the investigations are conducted in a timely fashion. Our role and the chief's role ended on March the 8th of 2018. This is different, for example, than an 11B application, because in a criminal law context, the time for the period of unreasonable delay runs until the trial starts, or even arguably sentencing on some occasions. This is very different. That's not what this section is about. It's not an abusive process application. This is about the investigation and the investigation only. This section, in my view, can't contemplate the board examining and adjudicating upon the delay that may be considered in having the application heard, because it requires the board to sit in judgment of itself. And that wouldn't make sense, whether this 3-year period post-investigation is reasonable. Again, if there's a concern that this period of delay has caused prejudice to the officers, then that can be raised in the appropriate forum, which is the hearing officer. But that is not the purpose of this application. So in my respectful submission, the time that is to be counted is April 22nd until March the 8th. And anything beyond that does not count in this decision. In the alternative, however, should the time count, and should Your Honor find that it does, in my respectful submission, it is a reasonable amount of time. The board, in this instance, recused itself of its own motion. And at the time, the Ontario Civilian Police Commission was conducting an inquiry into the conduct of the board and whether or not it was properly exercising its oversight of Thunder Bay Police Service, particularly in light of their treatment of Indigenous people. And because of that, and because our systemic review was tied to that, the board's inquiry as well, the board ought to recuse itself. But again, that was a decision that they made at the time, and I don't think it's appropriate to rule on whether it was appropriate. It then came before Your Honor, and Your Honors are well aware of the history that follows after, but that's not a time period that ought to be counted. Again, having regard to the purpose of the section, which is to ensure that the chief or our office conduct investigations in a timely fashion. So those are the submissions I have in terms of the time period, and I'd like to turn now to the factors that I would ask you to consider when looking at the delay in this case. And just some general principles first. The first being that, as my friend Ms. Walborn stated, it's not a limitation period. The 6-month period in my submission is also not presumptively unreasonable. What the section does is it triggers an inquiry into the reasonableness of the delay, but it does not create a presumption that any delay outside the 6-month period is unreasonable. It simply requires the board to approve or to adjudicate upon the reasonableness of the delay. In considering the investigation before it, the board should not, in my respectful submission, undertake a line-by-line review of the investigation. But really what's intended to happen is that the delay is considered as a whole in light of all the circumstances. Now, I do concede that certain periods can be examined with greater scrutiny. However, I think it would be an error to focus selectively on a timeline that's either too unreasonably narrow, unduly mechanistic, or to follow an approach that disregards the public interest in ensuring police accountability in appropriate cases. So really the question for Your Honor to consider is whether the delay was reasonable given the causes of the delay as a whole and in light of the circumstances. So one of the factors that I submit ought to be considered is the fact that there was a concurrent systemic review ongoing, and as well some of our resource limitations. The director in this instance decided that the complaint would be retained and a systemic review conducted concurrently. Now, I know I expect my friend Ms. Mulcahy will say that, well, you didn't have to retain the matter. If you thought it was a resource problem, you could have sent it to one of 53 other police services, or alternatively, you could have done the conduct first and the systemic later. But respectfully, that's really not the issue, and it takes away from the director's discretion. And I'll go through some cases in divisional court where they've deferred to the director's discretion in terms of how to handle complaints that have, like this one, several components, and not just a straightforward, I was on the street, the officer kicked me, it was an excessive use of force. This is much more nuanced and complicated than that. I think to answer my friend's comments though, given the social context of this matter, I think it can be fairly recognized that sending the complaint back to Thunder Bay for an investigation was not a realistic option. As stated in the complaint, and most recently recognized in the divisional court decision in the CBC matter, the social context in which this investigation took place is important. And there was at the time a very high level of distrust between the First Nations community and the Thunder Bay Police Service. And many Indigenous peoples in Thunder Bay believed that policing practices relating to them were racist. So simply stated, the Indigenous people and the Indigenous community did not trust the police. And we could not, I would submit, have sent this back to the Thunder Bay Police Service. And that's also a reason we couldn't send it back to any police service if the services didn't have the trust of the community. But also, although my friend says there are 53 police services, and that may have been true at the time, some are small, some aren't equipped to do this, and some don't appreciate the nuances in the relationship that was taking place at the time between the Thunder Bay Police, the Thunder Bay Police Service and the Indigenous people in Thunder Bay. So in my submission, the decision was made to conduct the review concurrently. There were very important and pressing social issues that required immediate attention. And we put as many resources as we had into dealing with the matter. And I appreciate my friend has said in her submissions, and it's not wrong, my friend being Ms. Mulcahy, that our resource issues really isn't an excuse for delay. And I think largely that's true because we do control which complaints we retain and which we don't. However, The divisional court in Martinez and in a case called Figueres, they're found at tabs 3 and 6 respectively, supported the approach that we'd taken. Now, both of these cases were what I had mentioned earlier. They were conduct investigations, but stemming from the G20. And they were two separate cases because Martinez was Toronto, so the 8317 application went to that board, whereas Figueres was York Region. And so there was a separate application there for the officer. And in Martinez, the board had held that the delay was reasonable in conducting our investigation because of the exceptional situation arising from the G20 subject. And while any delay attributable to lack of staff and resources would not normally lead to a finding of reasonable delay, it was not the case where in an exceptional case such as that. And in my respectful submission, this is on all fours with that. Similarly, in Figueres, we had explained to the board that the decision to conduct the systemic review was conducted in unique circumstances such as this. And while the board in its decision didn't speak specifically to that, the court held that if they disbelieved that explanation or if they disregarded it, then that they'd have reason to question the reasonableness of the board's decision, especially given that the public interest in the complaints against police generated by the G20, and there was a corresponding needs to have those complaints investigated by a neutral agency. So I raise those cases because I think that's exactly what the situation is here. There are great parallels between the G20 cases that we did, the 8317 applications that took place in those instances, and the matter here where we conducted a concurrent review. So what that speaks to is the fact that the courts have recognized that in larger cases, cases that are more complicated, where there is a need to have the matter investigated by a neutral agency, that some delay, that we would expect more delay than may be usual. And I do note that the divisional court has been deferential to the director's strategic decisions in terms of running them concurrently in that regard. With respect to the factors that I would submit ought not to be considered on this application, are any arguments that challenge the actual findings in the investigative report, concerns about procedural fairness, whether an officer was asked about a particular allegation or not, issues of prejudice to the officer. Again, this isn't an abusive process motion. We don't have sworn evidence before us. That evidence can't be tested on under cross-examination. And so the issue of prejudice, while it may be a factor in Forstall, and that was one of the first cases that said so, subsequent decisions like Martinez have ruled that it has much less weight, that it ought to be afforded much less weight. And I imagine the only time it would really be relevant is if the conduct were so oppressive as to show prejudice, or alternatively, there was some agreement that evidence had been lost or the officer couldn't properly defend the charges. But I would think you would need an agreement on that evidence, and we don't have that here. And lastly, factors such as the officer's background and community work and so much ought not to be considered. And again, these can all be considered in the appropriate forum, that being before the tribunal. So with all of that said, I'll turn to our investigation and the delays in that investigation. I think it goes without saying that this was a lengthy and detailed complaint. It was a complex investigation. It required us to understand the workings of the service more broadly, and it wasn't simply a review of whether the officers met appropriate standards. There was the whole issue of whether or not Indigenous people were being treated differently, and we found that they were, not just systemically, but in this investigation as well. When the complaint was retained on April 22nd, 2016, it was with the director for a period of approximately 2 months before it went to our investigations unit. And during that time, the director put together an investigative plan, as well as a plan for the systemic review. And it was important to design those plans carefully because we had to ensure that there was fairness to the officers for the conduct investigation, and also before releasing having a press release saying we were doing a systemic review, we had to have the terms of reference carefully planned out. So that took approximately 2 months, following which the matter was assigned to an investigator who subsequently became very ill. And I think at the beginning, probably the extent of the illness was unknown. And so it wasn't reassigned immediately. But after some time, when it became apparent that he couldn't return and conduct the investigation, it was given to an investigator with our office, and Mark Sandler came in to assist, and he was counsel and also assisted with the investigation of not simply the conduct, but the systemic review as well. And I'll concede that that's not an ideal delay. It is 6 months from the date that we retain the complaint to the date that, it's not quite 6 months, I'm sorry, 5.5 until the date that Mark Sandler comes on board with Ms. Wayne and they start doing the matter. But the idealness of the delay isn't the standard, it's the reasonableness. And again, given the broader issues that were taking place and what had to be considered in terms of running these parallel investigations, in my respectful submission, it shouldn't be found to be unreasonable in the whole context of the time. Following that, and there's a chronology in our materials, I don't plan to review it in any great detail, but as soon as the new investigators were assigned, the next day there was a disclosure request to the service that was fulfilled in 2 weeks. And within a month of the investigators assigned, we had identified 17 individuals as either witness or respondent officers. And then between November 7th and November 11th, there was more than a dozen witnesses, I believe, who were interviewed. And then from there until February the 9th, there were over 30 witnesses, a total of over 30 witnesses interviewed and investigations being conducted. Pausing here, there was one last witness interviewed on May the 29th. That's the investigator who had, having been retained by the family to do an assessment of the Thunder Bay investigation. He was interviewed late, but that doesn't speak to slowing down the investigation or anything of that nature. We had a very detailed investigative report from him, and it was decided that it was probably prudent at that point to interview him, but we did know what he was going to say by virtue of the report he had provided. Also, what was happening between February and May is that the OPP had been asked by the Thunder Bay Police Services to do a paper review of the investigation they had conducted into the death of Mr. DeBungee. And we were waiting for the outcome of that. Now that review was very different than what we did. They didn't interview witnesses and they weren't looking at misconduct, but we did want to see what that investigation turned up. Now, the end of the interviews, which really was towards the end of February, with the exception of the one in May, doesn't signal the end of the investigation. And it doesn't mean that you're done. The interviews have to be summarized. We brought in additional resources to assist us with that. The evidence had to be analyzed, it had to be reviewed in the context of other evidence, and the report had to be written. And also during this time, I note that we were working on the systemic review. And that was all happening together, and that was also, to preserve resources, that we could do everything instead of twice, do it more once. The investigative report speaks to itself. I'm sorry, did you have a question?
Well, you were breaking up for me. I don't know whether you were breaking. I don't know whether you were breaking up for anyone else. But go ahead. If it becomes a problem, I'll let you know.
Okay, thank you.
Just while we interrupt, your time was 30 minutes. It's now 30 minutes. I don't want to cut you off because I want your assistance, but I would ask you to bear in mind that you're now at the end of the scheduled time. How much more time do you think you need?
I really think I'll be no more than 5 more minutes.
All right, well, let's do it within 5. And okay.
Thank you.
Thank you. Go ahead.
So the investigative report, it was included in the application, was 126 pages in length. And I think the length of the report speaks powerfully to the time that was taken to transcribe, summarize, consolidate, and all of that. All the work that needed to be done on the investigative report, and then it had to be drafted and reviewed. And all of that was done by February the 15th, while we were also, doing work on the systemic review. So in summary, the delay resulted from a combination of factors that started with the complexity, not just of this investigation, but the systemic reviews and the important issues that had to be addressed. There were numerous interviews. We wanted to receive and consider the OPP review. There were extensive materials. And the public interest in this matter, in my submission, I know Ms. Mulcahy said, well, if the public interest was so important, why didn't you get it done? I don't think anyone could have done this investigation the way that we did. in 6 months, in the time that was permitted, especially with the concurrent systemic review that was ongoing. And I think the public interest really required us to take a good, deep dive into this matter, which in my submission we did, both in our investigative report and in the systemic review. So lastly, then just to touch briefly on the public interest in having this application granted, and I'll leave much of that to Mr. Falconer. Most recently in the CBC decision, the court confirmed that the public, and particularly the First Nations community, has a strong interest in the circumstances that surrounded the death of Stacy DeBungee and in the Thunder Bay Police Service's investigation of his death. The court held that there's a strong public interest in seeing that, if misconduct is found in regard to that investigation, those responsible are held to account. And so in my respectful submission, when one looks at the overall delay in this matter, it was some time, but if you have regard to the product that was produced and what was done, the important issues that were addressed both through our conduct and our systemic review, then in my respectful submission, I would urge you to find that the delay was reasonable. Subject to any questions you may have.
No, thank you. Thank you very much.
Thank you.
Mr. Falconer, are you and Miss Churchill? Who's going first?
I will be starting, Mr. Ferrier. I'd like to begin, if I may, by acknowledging that I'm speaking today from our Thunder Bay office as an invited guest on the land that is the traditional territory of the Anishinaabe people who have lived and governed themselves here since time immemorial. Their sovereignty over this land and relationship with it are inherent. This is Fort William territory, and they are recognized under the Robinson Superior Treaty, which was formed between the Anishinaabe people and the Crown. I also acknowledge the claims of the Métis people of Ontario who formed independent, culturally distinct communities in this region that persist to this day. I, as you know, act along with Ms. Churchill and Ms. Plasala by my side. We have the honor of representing the DeBungee family as well as the Rainy River First Nations community from which the deceased Stacy DeBungee comes from. I want to acknowledge the territory of Stacy DeBungee's home community, also the traditional territory of Anishinaabe people who have lived and governed themselves on that territory. Their sovereignty and relationship to the land are inherent and are recognized under Treaty 3. I make this acknowledgement as I understand many will be viewing these proceedings from that territory. We're here to talk about delay in respect of charges issuing relating to the conduct of police officers who were to have conducted a competent and professional investigation in relation to the death of Stacy DeBungee. So at its heart, and I don't think any of us should forget, and I don't mean for a minute, Mr. Ferrier, that you would forget, but I want to remind us all as legal counsel for the First Nation complainants. Stacy DeBungee and who he was and what was or was not done, his death is at the heart of this. He was 41 years old when he died. His body was found in the McIntyre River here in Thunder Bay the morning of October 19th, 2015. This was 2 weeks into the start of the coroner's inquest into the deaths of 7 Indigenous youth in Thunder Bay, many of whom were also found deceased in the rivers of Thunder Bay. There is a striking irony to how this unfolded. We as lawyers, and you know this, Mr. Ferrier, and my colleagues know this, We, in essence, are observers, and we try to be in a helping profession to other people's pain. I had the honor of being legal counsel to Anishinaabe Nation at the 7 Youth Inquest. I was in the course of examining a police officer about another death in which a press release had been issued stating that there was no foul play in that death prematurely. You can imagine the irony, with national attention focused on the 7 Youth Inquest, that yet again another Indigenous death would happen while the inquest was going on. And again, the Thunder Bay Police, utterly tone deaf to these issues, would do it again. I want to acknowledge Stacy's siblings who continue to feel the pain of his loss, in particular his brother Brad, who sits behind me. I have the deep honor of receiving instructions directly from him. He's very patient with his lawyers, particularly me. We often don't always make sense to our clients, and it's not because our clients are lacking, it's because we as lawyers seem to master communicating in the most difficult way. So Brad has been a tremendous source of inspiration and support. Stacy's community, Rainy River First Nations, their commitment to truth and accountability in Stacy's memory has gone on for 5 years. The death of Stacy DeBungee and the utterly failed investigation is a poster child for all that is wrong with how the Thunder Bay Police Service treats the deaths of Indigenous people. This is not mere rhetoric. I intend to, Mr. Ferrier, take you through the inventory of failings. They boggle the mind. Failure to take photos of the scene of the death. Failure to protect the scene of the death. Failure to interpret the scene as a potential homicide. Failure to interview witnesses. The list goes on and on. All of this matters. It's hard to hear or listen to, but all of it matters because we are speaking about the public interest in ensuring that these officers don't get a pass. The extension, if granted, allows the process to do its job. If the extension is not granted by you as a substitute for the board, Mr. Ferrier, the officers responsible for these failures get a pass. And the court speaks to looking at the public interest, and that's why I'm addressing this. What is sad is that today, and on behalf of the DeBungee family and Rainy River First Nations, I would be utterly remiss if I did not refer to the fact that the current chief of police of the Thunder Bay Police Service is not supporting the granting of the extension. The chief of police is taking no position on gross failures by her officers. I would be remiss if I didn't point to, as a matter of public interest, that the board ducked in terms of taking on this responsibility of granting the extension and instead appointed you, Mr. Ferrier, and I mean, obviously, no disrespect to you. The family took no position on your appointment. We said, if that's what it's going to take to get on with this, but the board had an option to just do its job, and it didn't. And the board remains MIA, and the chief remains MIA. And so in 2021, and we are speaking public interest, Mr. Ferrier, in 2021, I don't think you are going to find an Indigenous leader in this city of Thunder Bay who says things have really improved. And that's sad. So this isn't a historical artifact. The Broken Trust report came out. Boxes have been ticked about convening of committees. But in truth, very little has changed in this city when it comes to the utter lack of confidence Indigenous people have in the Thunder Bay Police. Very little has changed. I want to start with the related systemic review and to contextually set things up. I want to be clear that the request for a systemic review came from the First Nations public complainants at the same time that they sought the conduct investigation of the officers. In other words, the First Nations public complainants identified from the outset that there was a serious systemic issue going on in the city of Thunder Bay. I've referred to it already. I don't want to be redundant. But what I want to emphasize, Mr. Ferrier, is that that was way back at the time of Stacy's passing. And yet here we are years later with the same issues. If Ms. Churchill could turn up slide 4, please. The finding of the systemic report in relation to the board by now former Senator Sinclair. I got a lot of formers to identify. We lost our screen sharing. I should be at slide 4. There we are. In relation to the board, Senator Sinclair's report states, and I'm quoting from page 8 of the publicly released report in December 2018, and this is in relation to the board. These issues are not the result of behaviors by individual racists. They are indicative of a broader, deeper, and more systemic level of discrimination in which an unacceptable status quo is viewed as the normal state of affairs, maintained and perpetuated by the structure and operations of organizations and agencies mandated to oversee them. Next page, please. And this again is in relation to the board. The board has failed to recognize and address the clear and indisputable pattern of violence and systemic racism against Indigenous people in Thunder Bay. A finding, of course, by the former Commissioner of the Truth and Reconciliation Commission, a former Superior Court Justice. It is stunning that we sit here today with the same problems. The board is still MIA, the chief is still MIA. So when we talk of public interest, allowing the officers a pass in this ongoing saga of neglect and failing to step up, in my respectful submission, would be a grave error. Now, the Supreme Court of Canada actually spoke to the issue, and if you could turn up, please, slide 2, Ms. Churchill. The Supreme Court of Canada spoke to the issue of boards and the systemic issues that they, as police boards, may have to face in the course of addressing issues around racism. This is Justice Yacobucci in the Odabji case in Woodhouse. In that case, and I had the honor of representing the Odabji family, in that case, I, of course, lost on the issue of the board's liability. But the court had this to say on certain levels of systemic problems among police boards, and I really emphasize this, Mr. Ferrier, that this is eerily familiar. It is possible, I concede, that circumstances might arise in which the board is required to address a particular problem in order to discharge its statutory obligation to provide adequate and effective police services. If there was evidence, for example, of a widespread problem in respect of the excessive use of force in the detention of visible minorities, the board arguably is under a positive obligation to combat racism and the resultant use of excessive force. But as a general matter, courts should be loath to interfere with the board's broad discretion to determine what objectives and priorities to pursue or what policies to enact in pursuit of these objectives. Stopping there, and can you bring the slide down, please? Thank you. I want to emphasize, I understand totally that this is not, I'm hoping the slide will go down. I understand totally that this case, Mr. Ferrier, is not about excessive use of force, and there are public watching, and I want them to understand that the allegations in relation to these officers is about a totally incompetent and racist police investigation. But if you look at Justice Iacobucci's words, when he speaks to, if it were to arise that systemic racism that had a pattern of abuse of racial minorities was going on under the board's nose and they did nothing, that would be different. Well, this is it. The DeBungee case, the investigation into the death of Stacy DeBungee, is a poster child for all that is wrong with the Thunder Bay Police. This is hard to hear, hard to listen to, and it's hard to say. But it has to be said. It has to be said. The Broken Trust Report, and if you could please turn to page 6, Ms. Churchill. The Broken Trust Report, in essence, represents a companion report to the Sinclair report. What the Broken Trust Report by Oiprd did was to look directly at the service, whereas the Sinclair report looked at the board. Overall, this is a quote, I find systemic racism exists in the Thunder Bay Police Service at an institutional level. Next slide, please. Officers repeatedly relied on generalized notions about how Indigenous people likely came to their deaths and acted or refrained from acting based on those biases. Go back to the previous page, please. Now, that finding of systemic racism existing at an institutional level in the Thunder Bay Police Service, Mr. Ferrier, I don't know of an equivalent finding by a credible major report in respect of the entirety of a police service in modern day. I do not know of one. You can bring the slides down, thanks. And by that I mean the level of analysis into what ails this police service is unparalleled. The amount of outside help that has gone into the ills of this police service is unparalleled. And the findings are unequivocal, and they remain unequivocal today, as we hear a chief of police who takes no position in a board that declines to exercise its responsibility. So giving the officers a pass in this context is tantamount to ignoring a festering issue. And I say with respect that what is the responsibility of you in the shoes of the board is to ensure accountability. Now, it's interesting because it can't be ignored or lost that way back when, and I'm now talking because time really passes, I gotta say. October 2018, we were in front of Justice Pierce in relation to the in-camera issue in front of you, Mr. Ferrier. You've been with us quite some time. And the public is watching this, and we all as technicians, we all know why the delay happened. It was an important issue around whether these hearings should be public or not. And to be fair to all of us debating this issue, there wasn't precedent of a significant size to assist us. And so people took positions that it should be an in-camera hearing. That's code for a complete bar to the public. Not a publication ban, but the public should be shut out. And that was an original ruling by you, Mr. Ferrier. And we went to court on that. And to be fair to you, I'm not, excuse the language, sucking up. I'm simply saying that it was not a defined area of law. We went up on it. And in front of Justice Pierce, literally, we're talking within weeks, because it was what's called a motion to stay. So we were seeking to stop your hearing because it had been declared to be closed to the public. And Justice Pierce said the following, keeping in mind, and again, people from different parts of this province or country are watching this. Justice Pierce is a former senior regional justice here in Thunder Bay. And at page 10, she is heard the motion to stay, and she granted the stay. And she had the following observation to make. In my view on the facts of this case, it is important for the court to consider the extent to which the public can expect openness in administrative decision-making. Because of the complaint underlying this process, that policing practices related to Indigenous citizens in Thunder Bay are racist, it is even more critical that every step in the complaint procedure be dealt with transparently. Each step of the complaint process is a step on the way towards resolution, to which transparency must attach if the process is to be credible in the community. Failing to proceed openly will only sow distrust in the complaints procedure. It will do nothing to address the community's question about whether the Thunder Bay's approach to policing Indigenous matters is racist. And then page 13, please. The Ontario Court of Appeal, and I would be remiss if I didn't say, so then the Divisional Court then upheld the in-camera order. In other words, went a different direction than Justice Pierce did, and we went to the Court of Appeal. And in December 2019, the Court of Appeal held that this hearing was in fact to be open to the public, with the publication bans that you put in place, Mr. Ferrier. And in stating that, and reaffirming and quoting Justice Pierce, the Court of Appeal for Ontario said, quote, the racial tension between the Indigenous community and the Thunder Bay Police Service, the distrust of the Indigenous community towards the Thunder Bay Police Service, and the current state of administration of criminal justice all point strongly to the need for openness and transparency. Now that's Justice Sharp 14 months ago. If you can bring the slide down for a minute. As a justice system, Mr. Ferrier, I say we are all struggling and grappling with the challenges inherent in the society we've created. We fancy ourselves a free and democratic society, and we would like to think that the ugly things that go on don't go on, or we'd like to put a positive gloss on it, or we'd like to say, well, only there but not here. Well, you know, you need only look at the Ontario Human Rights Commission's reports on the Toronto Police Service around racial profiling in the last 24 months to know that that's just not so. The Thunder Bay Police Service is not like an outlier in terms of issues with its officers. Where the Thunder Bay Police Service is an outlier, Mr. Ferrier, is their stolid resistance to change. Their simple, absolute refusal to go in a different direction. Now, Chief Justice Strathy, and this is slide 11. So you had Sharp, Justice Sharp, in 2019 in December, speaking to the issues of the obligations on the system. Chief Justice Strathy in opening the courts. September 2020, we're getting right to present, Mr. Ferrier. Historically marginalized and vulnerable communities in Canada are asking whether our society, our governments, our justice system can really deliver on the promise of equity and justice for all peoples, or whether the promise is often simply justice, fair treatment, and prosperity for those who are privileged by race, color, or socioeconomic status. Next page, please. In Canada, the promise of a just society made 50 years ago has yet to be realized, particularly for many members of Indigenous, Black, and racialized communities, the homeless and the impoverished. Can we truly say that we have embraced reconciliation with our Indigenous communities? Or that we have done our utmost to repair the consequences of discrimination, isolation, and abuse of Indigenous, Black, and racialized peoples? Or that members of Black, Indigenous, and racialized communities are respected and equally important, see themselves as full and equally respected members of our society? Will this horrendous global pandemic teach us anything about the commonality of human suffering, the humanity and dignity of all peoples, and what it means to share this planet with others? Bring the slide down, please. So I'm an old fart, Mr. Ferrier, so, and you know that. And I've been at it for 30 years. I've had the honor of sitting as a bencher for just a little over 10 years. They'll get rid of me soon, I promise. Thank God for term limits. I want to say something, that when I started practicing, there wasn't no Chief Justice that was talking that way, right? Right? Chief Justice Strathy, his courage and his vision and his understanding of the social issues facing our society is inspirational. And I'm not ashamed. I've never been, I'm not entirely obsequious. I think you know that, Mr. Ferrier. I'm not afraid to be critical on behalf of my clients to that which I think isn't right. But when a leader of our legal system has that profound understanding and courage to call it out, you know, you look at that and you ask the question about public interest. You look at what the Court of Appeal said, not 14 months ago. You look at what Justice Pierce said at the start of the process here, October 2018. You look at what broken trust says. Giving these officers a pass is exactly what will simply continue the ongoing train of cynicism and mistrust. I don't suggest for 1 minute that this kind of prolonged complaint process is a good thing. Nobody thinks it is. It's not. It's hardly what you put in the claim of entirely defensible. There are lags by everybody, including the board, I might add. But the court requires you to weigh the public interest against it. So with less than ideal timing, right, spoken to by Ms. Sack-Snyder, and I hope I'm pronouncing your name correctly. I was showing off a bit there. I practiced it like 5 times. With less than ideal timing, you still can have reasonableness. Then reasonableness gets elevated when the public circumstances become enormously compelling. Brad DeBungee sits behind me. His brother's death still hasn't been competently investigated. Yes, it has not been competently investigated as of February 2021. They just announced in the last few weeks that the Broken Trust team is going to actually reopen it and do a proper job. And I want to say on behalf of the family, on behalf of Rainy River First Nations, you know, under the title Better Late Than Never, this is great news. And they have confidence in this investigative team, and they believe they're doing their best. But I'll tell you why they have confidence, because they aren't the Thunder Bay Police. I'll tell you who delayed this investigation for years, the Thunder Bay Police. They are not the Thunder Bay Police. Will they identify the precise circumstances of this death? Hard to say. I want to take you through, Mr. Ferrier, why it's hard to say whether they'll be able to unearth the circumstances of this death. What was done at the time of the death to make it almost impossible to find out the truth. The sheer incompetence involved in this death investigation is stunning. So it's page 14 of the slides. These are all findings. They're all referred to starting at page 14. All of these findings are referred to in the report. You'll see the site at the end of each quote. This is the Oiprd investigative report findings about this very case. So let's not get confused. I am now, with my tortuously circuitous submissions, I want everybody to know I've now gotten to the point of speaking to the actual facts relating to the misconduct by these officers. The CIB investigators prematurely determined the death was non-criminal. The available evidence did not support the conclusion that foul play had been excluded. This infected the entire approach to the minimal investigation which followed. And just to emphasize, for anyone that doesn't know, they did not work on the assumption that this could have been a homicide. They excluded that possibility before they even had a post-mortem. Next slide, please. No formal statements were taken from any of the individuals who were with the deceased shortly before his death. These individuals should have been formally interviewed at the earliest opportunity. They didn't interview witnesses. Next slide, please. The CIB investigators, most importantly, officer number 1, who wants a pass today, right? Wants a pass, did not review on an ongoing basis supplementary occurrence reports in the investigative file. And as a result, this is the lead, right? Was unaware, for example, of the informal interview with KK conducted at the scene by a uniformed officer, in which a witness described a physical altercation between Indigenous men at the scene the night before the deceased body was found. Formal interviews should have been conducted of KK and others informally interviewed by uniformed officers at the scene. Next slide, please. The CIB investigators provided inadequate or no direction to the forensic identification unit in a manner consistent with treatment of the sudden death as a potential homicide. No video was taken of the scene. No photographs of the body itself or the riverbank in close proximity to the river were taken. No consideration was given to holding the scene until the autopsy had been conducted. No measurements were taken at the scene. Bring the slides down, please. This is an absolute travesty. Nobody should lose a family member and have this kind of neglect attached to the investigation of the death. What message has been sent to Indigenous people? And it is so important to remember what I referred to before, Mr. Ferrier. All of this was happening in the small city of Thunder Bay, where not a 20-minute walk away, an inquest was going on into the deaths of 7 youth, in which a prominent issue was the lack of respect of the Thunder Bay police for Indigenous people as victims. Utterly tone deaf. And today, in February 2021, the chief takes no position. It goes without saying in a homicide investigation, and I'm just a lawyer, that the person last seen with the deceased, with the victim, the person last seen with somebody who dies, probably has relevant information to provide about the cause and means of death. It goes without saying. Slide 18, please. The Thunder Bay Police Services efforts to contact FF, who by some accounts was the last person known to be alone with the deceased, were sporadic and were given the lowest priority. The interview conducted with FF took place a long time after the material events, given the lowest priority. Next slide, please. The matter was not dealt as an investigation subject to major case management. It should have been. Even if it was not formally so designated, there was no investigative plan, no organized evaluation of ongoing steps to complete the investigation, all stemming from a mischaracterization of the nature of the investigation. Next slide, please. No broader canvass of the local businesses and area residences was conducted. Standard fare for a potential homicide. Next slide, please. Officer 1 chose not to meet with civilian witness 7, the private investigator and former homicide detective. He said that he was not going to speak to any private investigator about the case. Next slide, please. Because of the premature determination that this was a non-suspicious death, no forensic examination was conducted on the exhibits. Please bring the slides down. In representing the family of Stacy DeBungee in and around the time of his death, I retained a private investigator. That private investigator was given a letter of authorization, and he went with Brad DeBungee to the police service. The investigator would not talk to the family and the private investigator. Had no interest in what they had to say. Let's ponder that for a moment. You have a family member, the brother of the deceased, and you don't want to know what he has to say. He barred the private investigator. That is, wouldn't talk to him, no interest in talking to him. The family's private investigator. And today he wants a pass. Today he wants a pass. He says he wants a pass, officer number 1, as do the other officers, because the amount of delay has prejudiced the investigation. The irony. These officers want a good investigation. The irony. Slide 23 is the last slide on the findings, Mr. Ferrier. The evidence overwhelmingly supports the inference that officers number 1 and 2 prematurely concluded that Stacy DeBungee rolled into the river and drowned without any external intervention. It can also be reasonably inferred that this premature conclusion may have been drawn because the deceased was Indigenous. It can reasonably be inferred that the investigating officers failed to treat or protect the deceased and his family equally and without discrimination based on the deceased's Indigenous status. You can bring the slides now. In 2003, when I was in front of the Supreme Court of Canada on the Adjudicated case, I had reason, because I didn't have all this gray and white hair, Mr. Ferrier. I hadn't lost enough cases yet. I put in a factum. I was in the Supreme Court of Canada. I had the honor of acting for a family on a major abuse case. And I put in a factum, and on the cover of the factum, and it's at page 3 of the slide, we quote Ron Corelli and Duplessis. And you, Mr. Ferrier, and I, well, we know what Ron Corelli and Duplessis means for the rule of law. Every official from the Prime Minister down to a constable or a collector of taxes is under the same responsibility for every act done without legal justification as any other citizen. We'll bring the slides down. Now, this isn't the impeachment hearing that's being run in the US right now on day one. I promised myself somehow I'd get a reference to that in there today. And this may not be the trial of the century, but this poster child for all that is wrong in Thunder Bay can't stop on a technicality today. It's not right. Forget the Prime Minister, forget the collector of taxes. You just got this constables. You've got these officers. You've got a chief of police and won't take a position. You've got a board that's MIA. They can't get a pass. They need to be accountable. They call their evidence of prejudice at the appropriate time. They'll have their opportunity. They'll show us all the ultimate irony that they feel they didn't get a good investigation. You know, my kids are too old for me to talk about high school anymore. But if I had taken one of my kids in grade 9 and asked them what would they do with the scene of the death, pictures and yellow tape would just come out of their mouths because they watch TV. Seizing exhibits, interviewing witnesses. In order to fail to do what they failed to do, they had to do this kind of neglect deliberately. This was not a mistake. The inquiry into the murdered and missing Indigenous women and girls, it was all about this level of callous disregard for Indigenous lives. They can't get a pass today because in 2021, just as Chief Justice Strathy recognized, we have an absolute obligation to hold them accountable. They can't get a pass because the message you send in giving them that pass will rebound around the country. Mr. Ferrier, my submission is that they are lucky that this is all they face. They are lucky. But that's all we have. The Oiprd, under the leadership of Director McNeely, produced a report that is unparalleled in my 30-year career. I have never seen such a comprehensive, systemic review of a police service, and equally, I have never experienced such an across-the-board damnation of a racist police service as is reflected in broken trust. The DeBungee case is the poster child of all that went wrong, and now we have to make it right. So respectfully, they ought not to get a pass. We need to allow the process to do its job. The transparency you've ensured, Mr. Ferrier, by the rulings you've made while maintaining the publication bans around the names of the officers, and I remind everybody of that as an officer of the court. I just don't want to see mistakes get made. You've created a transparency and access to the process as is proper. It needs to continue. Justice Pierce's words need to ring out loud and clear about what ails the city of Thunder Bay and what's going to be necessary to fix it. Justice Pierce is a very senior judge local to this community, and she got it right. And the Court of Appeal said she got it right. Now we have to get it right. Ms. Churchill sent me a note that she doesn't think she needs to add anything to this. She makes the calls on these things. So that concludes my submissions, Mr. Ferrier, and I thank you for your patience.
Thank you, Mr. Faulkner. We'll take a 15-minute health break at this point, and when we resume, Ms. Mulcahy will make her submissions.
Do I get a credit for my reply because I ended early?
No, it doesn't work that way, Mr. Faulkner. You know that. And I should add that your reference to your senior years. From my perspective, Mr. Faulkner, you're a mere youngster.
Thank you.
It'll take 15 minutes, and we'll resume at 3:15.
Very simply commentary on you always say.
All right, Ms. Mulcahy, you're on.
Thank you. This is an extension application under section 8317. Your only jurisdiction is to determine if you are of the opinion that it was reasonable under the circumstances to delay serving the notice of hearing. Your role is not to deal with systemic issues. Your role is not to deal with the merits of the allegations. I can put on the record here, my clients deny that they engaged in an incompetent investigation or a racist investigation, neither of which, frankly, were alleged by the Oiprd, but that's not your role. And the Court of Appeal and the Divisional Court are clear. That's not your role. The Court of Appeal, at paragraph 45, held enforceable.
Paragraph 45 of what?
Of the Court of Appeals decision in CBC versus Ferrier.
Thank you.
In Forstall versus the Toronto Police Services Board, the Divisional Court held at paragraph 44 that as an extension hearing does not determine the merits of allegations or impose discipline. The decision is administrative in nature, purely procedural. So this is not the forum to deal with the merits of the allegations. And what's noteworthy is in the written materials that were before you, counsel for the complainants had indicated that this is not the forum to deal with the denials of the police officers with respect to the allegations against them. As we see from the Court of Appeal, it's not just not the forum to deal with the denials, it's also not the forum to deal with the merits of the allegations. The merits of the allegations are irrelevant. And the Divisional Court in Coombs, which is in the Book of Authorities of Thunder Bay Police Service, paragraph 7, the Divisional Court held it would appear that the general scheme and intent of the Police Services Act is to have disciplinary proceedings commenced within 6 months of the knowledge of possible misconduct unless there are extenuating circumstances. So the question here is, are there extenuating circumstances? Was the delay reasonable under the circumstances? And I would submit it was neither reasonable nor are there extenuating circumstances. And taking you to Forstall, which is cited with approval by the Court of Appeal, Forstall in the Divisional Court highlights this is not the forum to deal with the merits, but also Forstall deals with the time period. And it directly responds to the submission made by the Oiprd, who suggests that the time period is from April 22nd, 2016 until March 8th, 2018. And respectfully, that's wrong. The period before you is from April 22nd, 2016, which is the date that the Oiprd retained the complaint, until today. That's the totality of the delay. However, I would submit what period of time you should focus on is from April 22nd, 2016, until the day we were supposed to have the board meeting, which was September 21st, 2018. So that's 29 months or 2 years and 5 months. And we know here we are today, it's almost 5 years. But if we go to the case of Forstall, which is both in the Oiprd's brief and the chief's brief, at tab 4 of the Oiprd's brief, and I'll just take you to the paragraph numbers. Paragraph 44, which is what the Court of Appeal cited. It is true that the decision has a serious impact on the officers because there will be no disciplinary proceedings if the board does not find the delay in serving the notices of hearing to be reasonable. However, the board's decision does not determine the merits of the allegations against the officers and thus does not engage their right to continue in their employment. We conclude that the decision is administrative in nature, directed at the investigation and pre-charge stage, and determining only whether the circumstances preceding the service of the notices reasonably warrant the delay. So when Ms. Sachs-Schneider invites you to have an end date of March 8th, 2018, respectfully, that's wrong. Because you're to look at not only the Oiprd's investigative delay, as the divisional court indicated, but also pre-charge stage. And the pre-charge continues from March 8th, when the Oiprd provided their justifications for the delay, to when we were supposed to have the board meeting, September 21st, 2018, or to today's date. And I acknowledge it's rather difficult to attribute any unreasonableness in the time period between September 21st, 2018 to today, because we were dealing with unique issues at different levels of court. But you're in a position where you can deal with the delay from March 8th, 2018 until September 21st, 2018. And I would submit that that period of time is unreasonable. So you've got a start date of the retention, April 22nd, 2016, and an end date as to the date that you as the board would decide whether there would be service of the notices of hearing. The divisional court in Forstall repeats that you're not to determine the merits, and that's also at paragraph 50. The board's decision does not determine the merits of disciplinary charges, but we agree that its decision is important to an individual since a determination that the delay was unreasonable will put an end to the disciplinary proceedings. And the other paragraph I'd invite you to look at in Forstall is paragraph 84, where the divisional court highlights you have a limited issue. It's your opinion about whether the delay was reasonable under the circumstances. And they say subsection 6918, which is your predecessor section, directs the board to form an opinion whether in the circumstances it was reasonable for the chief to delay serving the notices of hearing. In coming to its opinion on this limited issue, it is for the board to decide how much weight to give to the relevant factors. It was for the board to evaluate the complexity of the investigation, the potential prejudice to the applicants, and the public interest in seeing police misconduct adjudicated, among other factors. So section 8317, it's clear on the case law before you, is a mandatory section. It's not a pass. It's not a technicality. It's a jurisdictional section. It's presumptive. And the focus is to ensure that there's a prevention of investigative delay. And also, as the divisional court found in Goff, to ensure a speedy disciplinary process. So again, that addresses squarely Ms. Sachs-Schneider's submission to you that the time should end March 8th. The time continues until you as a board decide whether or not there should be service of the notice of hearing. And in fact, the Oiprd is aware that boards around the province have considered the time up to the date of the board meeting and have attributed unreasonableness to police services other than Oiprd delay. So it's not a guideline, as some of the written material suggests. It's not a procedural check-in, as some of the material suggests. So that gives you some sense of what Section 8317 is about. So you've had some submissions here that you should see criticism of the chief taking no position at this board. Again, this is completely common. It's completely routine. It's nothing unique to the Thunder Bay Police Service chief. When it is an Oiprd investigation, an Oiprd directing an application, it's the Oiprd that has the firsthand knowledge. This is common and this is routine for chiefs of police to take no position because it is an Oiprd matter. So nothing sinister can be reflected on that, and it has no relevance whatsoever to your decision making. Secondly, the submission was made to you before the break that, again, you should take into account that the board has ducked out. The board has abdicated their responsibility. Again, that submission with respect has no relevance whatsoever before you, particularly in light of the Court of Appeal holding in CBC versus Ferrier at paragraph 71. The board appropriately applied quasi-judicial considerations when it decided that there could be a reasonable apprehension of bias if it were to consider the extension request in the ordinary course. So the fact that a Superior Court justice has assigned you to this case and we're not in front of political appointees or councilmen or councilwomen is irrelevant. And the Court of Appeal have held that the Police Services Board in Thunder Bay acted appropriately in recusing themselves and having you appointed. So that's a red herring and has no relevance to the matter before you. So when you look at the chronology and you look at the record before you and the submissions, what you see is an approach from the Oiprd that is not indicative of dispatch. It's not indicative of reasonable delay. We see that the Oiprd commences their investigation just days before the end of the presumptive period of service of a notice of hearing. They don't even start their investigation until almost the end of the 6-month period. The first request for any materials from the Thunder Bay Police Service is on October 6, 2016. So although they had it on April 22nd, the Oiprd, the first request to the Thunder Bay Police Service for any material is on October 6th. And as the record shows, that's very unusual. Normally, when the Oiprd retains something, the cover letter requests, demands, directs a police service to provide them the relevant material so they can get going on their investigation. That didn't happen here. Doesn't happen until October 6th. They don't conduct a single interview within the 6-month period. The first interview, Mr. Ferrier, is conducted November 9th, 2016. That's 6.5 months after their retention. So that highlights that the approach was not one of dispatch. One of the excuses or justifications of the Oiprd for the delay is we did a number of interviews. Well, when you look at the record before you, the interviews took place 9 days, on 9 days, and yet clearly a time period of 9 days within 29 months is not a justification for the delay being reasonable. And not a single one of those interviews was done within the 6-month time period. Ms. Sack-Schneider fairly acknowledged that the last interview, which was conducted on May 29th, 2017, wasn't necessarily necessary because the OIPRD had since March 2016 that investigator's report, but they decided they wanted to do it, and no criticism should be made to them for doing that interview. But the gap between that last interview, which is May 29th, 2017, until the release of the investigative report on February 15th, 2018, was 8.5 months. That's, again, longer than the presumptive time period for service, which is 6 months. So you have before you a record of no effort whatsoever by the OIPRD to comply with a 6-month time period. The record also shows that there's no delay whatsoever by the respondent officers. They did the interviews when asked of them, with minimal notice at that. In addition, the record shows that no delay can be attributed to the Thunder Bay Police Service. And there are investigations where the OIPRD will blame the service for the delays in getting material. That's not in the record here. We see the file being provided to the OIPRD within 12 days of being asked for it. We see the Thunder Bay Police Service arranging interviews, important interviews, with only 3 days notice. So interviews were typically, they were only given 3 or 4 days notice, and the police service and the officers went to the interviews, even though they had minimal notice that the OIPRD wished to interview them. So no delay can be attributed to either the officers or to the service. With respect to the OIPRD, we see throughout, and their chronology, I commend them for being fair. The chronology shows that the investigation was not conducted in a timely manner. In addition, on top of the investigation, after that, the process highlights unreasonableness of delay. The service of the investigative report from the last interview in Thunder Bay, February 2017, until the service of the investigative report, a full year. From the interview in May 2017 until February 2018. In addition, even though they knew it was so far beyond the 6-month time period, there was still a delay from February 18th until March 8th, when they put together their application or their justifications for the delay, because nothing could happen until they put in paper what they said there was their justification for the delay. In addition, when the litigation was going on to appoint yourself, to appoint a disinterested person under the Public Officers Act or the Public Officials Act, the OIPRD put a factum in which they fairly acknowledged that they were to blame for the necessity of a public officer, a public official needing to be appointed. And that was because the board sought to recuse themselves because of the outstanding systemic review by the OIPRD and by OCOPS. So the delay in terms of the recusal of the board and the need to appoint another board, a public officer, we can see in the record before you, I've made mention of that in my written submissions. The board blamed it on the reasonable apprehension of bias because of that outstanding systemic review of the OIPRD. We can also see in the record that there was delay caused by the complainants. So with respect to the recusal of the board, we see in the record that the complainants demanded that the board be overseen by an administrator. In addition, you see on the record that even the agreement that there should be a public officer or a public official, that it took 1 month for there to be a response. And we see in the record that actually 6 emails, 6 letters had to be sent from the Oiprd to complainants to get a response with respect to there being an appointment. So that's from June 4th to July 4th, 2018. So looking at different time periods, and I acknowledge that you look at the totality of the time, but the totality of the time period is clearly unreasonable. But some of the time periods will assist you in showing how unreasonable this is. So I've already made reference to April 22nd, 2016 to September 21st, 2016, 29 months. Then you see May 29th, 2017, the last investigative step, the last interview, to February 15th, 2018, the release of the investigative report. Then from February 15th, 2018 to September 21st, 2018, that's 7 months. And of that 7 months, we know from February 15th to March 8th, everything waited for the Oiprd to release their letter setting out their submissions about the justification for the delay. From March 9th to July 25th, that's all because of the board needing to recuse themselves because of the Oiprd's outstanding systemic review. So that's 4.5 months with respect to the systemic review. And we see 1 month of that is attributed to the complainants who did not respond to 6 repeated requests by the Oiprd. We also see of relevance, which highlights unreasonable delay, from April 22nd, 2016 to October 6th, 2016, 5.5 months before there's any request for the materials from the Thunder Bay Police Service. Then we see from April 22nd, when they retain the complaint, it's 7.5 months before they interview Mr. DeBungee on December 2nd, 2016. It's 9 months before they interview the co-complainant, Chief Leonard, on January 12th, 2017. And it's 13 months before they interview the private investigator, which report they had since March 18th, 2016. So from February 9th, 2017 to February 15th, 2018, from the last interview in Thunder Bay to the release of the investigative report, that's 1 year. And from the date of retention, April 22nd, 2016 to February 15th, 2018, that is 22 months. So at the time that the investigative report was released, at the time of the board meeting that was expected September 21st, 2018, the systemic review was outstanding. The systemic review, as Ms. Sachs-Schneider noted, came December 12th, 2018. But what's important, Mr. Ferrier, is under Section 57 of the Police Services Act, systemic reviews are completely at the discretion of the Oiprd. It's something they choose to do. They are not mandated to do by statute. Unlike with respect to conduct investigations, where under Section 61 and Section 68, they must take it on, they must investigate it or refer it to another police service to investigate. A systemic review, there's no jeopardy. Obviously, for a complaint and a disciplinary hearing, there is jeopardy. So it cannot be reasonable that a systemic review, which is completely at the discretion of the Oiprd that does not result in any jeopardy for anyone is a justification reasonably for delay. It was a choice that the Oiprd made. And we can see all throughout dates in which the systemic review was going to come out, then it didn't. So first, September 23rd, 2016, we see in the record, the Oiprd said, we will wait the outcome of the conduct investigation. Well, then things changed. Then there was an announcement on January 31st, 2017, that it would be completed spring 2017. That didn't happen. Then there was an announcement, September 28th, 2017, it would be completed by the winter 2017. That didn't happen. Then January 10th, 2018, it was announced late spring 2018. It didn't happen. March 7th, 2018, it was announced it would happen end of May 20th, 2018. It didn't happen. March 8th, 2018, they said it'll be end of May, June 2018. It didn't happen. June 1st, 2018, they said, you know what? It's going to be end of June 2018. It didn't happen. June 26th, 2018, they said it would be in August 2018. And then we see on the record, as Ms. Sachschneider indicated, it happened December of 2018. And why is this all important? Because it highlights the delays not reasonable. And it's also because of this outstanding systemic review, the board had to step aside, which caused the delay from March until July. One of the considerations that Forstall, the divisional court, looked into is do the nature of the allegations trump the requirement for expeditious resolution? And I would submit in this case, they do not trump it. Issues with respect to the neglect of duty, as Ms. Sachschneider noted, have been dealt with in the systemic review. Issues of differential treatment have been addressed in the systemic review. Also, when you look at the context in the record before you, you have numerous witnesses, including the coroner, the paramedic on scene, and other witnesses who were interviewed by the Oiprd, who all did not see any differential treatment. And we also, as noted, one of the officers who it's being sought to serve a notice of discreditable conduct on was never even interviewed about this allegation. So if this was so serious, you know, why was the officer not interviewed? But this submission is to highlight the nature of the allegations, and the public interest has been addressed by the systemic review report that was issued in December 2018. So these criticisms of Thunder Bay Police Service at large, these criticisms of the chief, these criticisms of the board, they were dealt with in the systemic review. And if the criticisms continue on, these individual officers, including a constable, do not bear responsibility for the actions of the Police Services Board or his or her chief. And one of the submissions that is made is that if this is all so serious, why does the record show no timeliness, no dispatch? Another consideration that the divisional court have indicated that you should take into account is that of complexity of the investigation. And when you look at the record before you, it's 9 interviews, and I would submit it's not complex. So the excuses or justifications put forward by the Oiprd include the number of interviews, And firstly, that is not a reasonable excuse since no interviews started until November 9th, 2006. And they were completed except for one in February 9th, 2017 and one May 29th, 2017. And they were only done over 9 days of that 29-month period. The other excuse given by the Oiprd is the number of respondents. And again, that's completely irrelevant because whether you are a respondent officer or a witness officer, you would still be interviewed. So the designation is irrelevant. The third excuse provided by the Oiprd is the OPP review. Well, again, that's a red herring and irrelevant. And it's sort of ironic because the Oiprd submitted to you that they could not give this investigation to another police service, and yet the Oiprd sought to await the results of the investigation or review of the OPP. But why it's irrelevant is the Oiprd had the OPP's review July 21st, 2017. So it was still 7 more months before the release of their investigative report. A fourth justification by the Oiprd, which I would submit is not reasonable, is they say we had materials to review. Well, they had the complainant's material since March 18th, 2016. So that's not a justification. We also see in the chronology, there's no attribution to any significant time, if any, taken by reviewing the materials. Also, as noted, they had the Thunder Bay Police Service materials as of October 2016. They got it within very quickly. So much of the Oiprd's justification is the systemic review. And as I've highlighted, the Police Services Act notes in section 57, it's voluntary, it's discretionary. It's completely the choice of the Oiprd versus a disciplinary complaint under section 61, which is mandatory, of which there's jeopardy. So a discretionary undertaking cannot be a reasonable justification for delay. In addition, the systemic review highlights that concerns of public interest have been addressed through the systemic review. And also, we know that after the investigative report was issued, the systemic review caused significant delay in the proceedings before you from March 8th, 2018 to September 21st, 2018, because the board had to be recused because of the outstanding systemic review, and you had to be appointed. The other factor the Oiprd submits justifies their delay is the length of the investigative report. And yet I would submit the Oiprd submissions acknowledge that that's not reasonable when they acknowledge the resources they had, that they had Mr. Sandler's office summarizing, transcribing interviews in a timely manner. You have no information whatsoever before you as to the time it took to prepare the investigative report. They assert in their written materials they had to take time to review relevant jurisprudence. There's not a single piece of jurisprudence referred to in the investigative report. So they assert, well, it took extensive time, and yet they also say we had other supports to facilitate the preparation. And as Ms. Sack-Schneider has acknowledged, other jurisdictions have held that this is not a justification for delay, the time that it takes to do the investigative report. The Oiprd in their written materials says that concerns about resources, but they've also acknowledged in their materials that resources were not an issue. It's not an excuse. They also point out, they said, well, we had out-of-town investigators. Well, the Oiprd are out-of-town investigators in every case unless they're investigating the Toronto Police Service. And the chronology shows that there were no logistical challenges whatsoever by the fact that they were out-of-town investigators. The Thunder Bay Police Service on 3 days' notice would arrange interviews with numerous officers. So submissions are made, well, about the impact on the public interest or on public confidence. But if that was such a concern, we don't see any compliance right from the start. The approach from the start is not one of compliance. And many of these concerns are addressed in the systemic review, including Mr. DeBungee. The Oiprd have indicated that they have sought to keep it separate, and yet they deal with Mr. DeBungee and the allegations there squarely in the systemic review report. So before you, the Oiprd made submissions about the history of the systemic review. And that history was helpful in highlighting to you that concerns about public interest have been addressed by that systemic review report and by the response of the Thunder Bay Police Service to those recommendations. The Oiprd have submitted to you that, well, if there are certain concerns that can be addressed by the hearing officer, well, the hearing officer does not address your question, your answer about whether or not your opinion is that it was reasonable to delay service of the notice of hearing under the circumstances. So one can't say, well, this will all be dealt with by the hearing officer. The hearing officer does not answer the question at section 8317. The Oiprd made mention of the divisional court case of Martinez in the context of the G20. That case is very distinguishable because in that case, the Oiprd had retained and were conducting investigations into 212 other G20 complaints. So that's very different. What we have here is this matter, one other matter in Thunder Bay, which involved only 2 interviews, and then we have a discretionary systemic review. So Martinez is very different than what happened here. What we have here is the choice of the Oiprd not to comply with the Police Services Act and spending more focus on the systemic review. This is, again, not the forum to deal with the allegations or the merits of the allegations. And this is an example of why it's not the forum. At the start of Mr. Falconer's submissions, he said that there had been a failure to take photos of the scene. And yet the Oiprd report refers to photos being taken by ident. But again, this isn't the forum to have a debate or a dialogue about whether or not photos were taken. The sole issue before you is the reasonableness of the delay. The submission that little has changed in the community, again, that's not a factor respectfully with respect to your decision about the delay in service of the notice of hearing. How does that justify the reasonableness of the delay? And again, that's not attributable if there hasn't been, if there has not been changes in the community. That lies at the foot of the Police Services Board, that lies at the foot of the chief, but that's not the forum here at section 8317. The reference to the Sinclair board report and the criticisms of the board, again, the board, this is not what an extension application is about. And at any disciplinary hearing, the board would not be a party. So criticisms of the Police Services Board found in the Sinclair report do not in any way assist you. And as the Court of Appeal held, the board acted appropriately in recusing themselves. And frankly, a constable could not be held responsible for issues with respect to a political board. So a theme was these officers are getting a pass, that they would be getting a pass over a technicality. Well, as I've already submitted, it's not a technicality and it's not a pass. It's a statutory provision, which is a requirement of the Oiprd, which is a requirement of the chief of police. And it's no pass for anyone to have this hanging over their heads for almost 5 years. So criticisms of the police service, systemic criticisms of the chief, systemic criticisms of the board do not provide a basis to find that the delay was reasonable. You had sent all counsel an email in which you sought the answer to a question. I don't know, Mr. Ferrier, if you still need that question answered.
Well, I haven't heard from any other counsel about it, so I guess no one saw any merit in the questions that I raised.
Well, I'll answer it. So you had asked, you said it's the responsibility of the chief of police to serve the notice of hearing. And you said, in this case on the record before you, it could be argued that the chief acted expeditiously throughout. The notice could not be served until the Oiprd report was completed. The chief then commenced the extension application, and you referred to 2 sections in the Thunder Bay Police Service application. And you said, shortly put on the Police Services Act provisions, could that be an answer to the delay issue? So firstly, the chief in her addendum asked you to disregard those paragraphs 3.
Oh, I missed that.
Second,
I missed that. Sorry.
Okay. That's okay. Secondly, and there's no dispute here, I believe, between myself and the Oiprd and the chief about this. Under section 61(5)(c), this matter was retained by the complaint, by the Oiprd. And as Ms. Sack-Schneider fairly said in her submissions, the Oiprd basically stands in the shoes of the chief. So the fact that the chief was expeditious once receiving it from the Oiprd is completely irrelevant, because as we see from Forrestal, that paragraph 44, we're looking at both investigative delay and pre-charge delay. So the investigative delay is all attributable to the Oiprd. So the fact that the chief was expeditious afterwards is not an answer for the Oiprd's investigative delay. And then after the chief was expeditious, we've got this issue about the board having to recuse itself because of the systemic delay of the Oiprd. Also under the Police Services Act, section 68(3), where the Oiprd If at the conclusion of the investigation, the independent police review director believes on reasonable grounds that the conduct of the police officer who is the subject of the complaint constitutes misconduct as defined in section 80 or unsatisfactory work performance, which was not one of their findings, he or she shall refer the matter together with the written report to the chief of police of the police force to which the complaint relates. And then section 68.5 says, subject to subsection 6, the chief of police shall hold a hearing into a matter referred to him or her under subsection 3 by the independent police review director. So that highlights why the OIPRD's investigative delay is relevant to you, and the fact that the chief was expeditious on receipt is not the answer to the query before you. So one of the submissions made in the written material was that it would have been impossible for the OIPRD to have served the notice of hearing within the 6-month period, as the misconduct investigation was still very much ongoing. And you see from the record before you, there was no attempt to do any interviews. They had barely started within that 6-month period. Another submission that's made in the written material is that the complainants have the right to have the matter proceed to a hearing. And on the case law before you and under the Police Services Act, respectfully, that's not correct. And they refer to the decision of Endicott. And Endicott, which is found at tab 6 of their brief of authorities, does not lend support for that proposition. Because at paragraph 44, the divisional court holds, but for a decision by the IPRD under section 60 bracket or possibly jurisdictional concerns, the complainant in this case would be entitled to an investigation of her complaint, either by the IPRD or the chief of police, so a recognition of jurisdictional concerns. But more importantly, at paragraph 45, the divisional court indicates, in my view, the more accurate way of expressing it is that Ms. Endicott has a right to file a complaint, a right to have that complaint investigated, and a right to have it proceed to a hearing, comma, provided relevant legislated preconditions are met. And that precondition is section 8317. So the written submissions fail to acknowledge that there's a legislated precondition. And the same, the divisional court also at paragraph 51 at that decision also notes that the PSA is structured and worded quite differently from the Coroner's Act, including the filing of complaints alleging wrongdoing and entitlements to an investigation and to a hearing unless certain conditions specified in the legislation are met. Well, it's my submission that the legislated preconditions are not met here. And in addition, in the divisional court, in the matter of CBC, they noted, relying on the Supreme Court of Canada in Penner, that complainants have no right to any particular remedy. So section 8317 still must be complied with. So when you take into account the nature of the investigation, the breadth, the length, the complexity, and the efficiency, I would submit all of that shows that investigative delay, it shows unreasonableness. And because of the systemic review report, that caused pre-charge delay after the investigative report was issued and provided, and that is attributable to the Oiprd. So on the basis of section 8317, I would ask you to deny the application and express the opinion that it was not reasonable under the circumstances to delay the service of the notice of hearing. Thank you.
Thank you, Ms. Mulcahy. Reply, Ms. Walburn.
Thank you. I'll be very brief. I just wanted to touch on one thing, and I thank Ms. Mulcahy for bringing it up, brought up by Mr. Falconer. Just to put on the record simply that I think that it's respectfully kind of inflammatory to suggest that Chief of Police taking no position on an extension application equates to condoning behavior. Again, and it's a good attempt at confusing the point of an extension application, but that an extension application is simply to determine whether the delay was reasonable. The chief does not have delay here. It is the Oiprd. They are here to discuss and argue their delay. So it is not for the chief to take a position on that. And I simply wanted to make that point again, so as to not lose sight of what an extension application is properly for.
Thank you. The Saxonator. The Saxonator.
Sorry, I'm struggling to unmute myself. My apologies.
It's all right. I was wondering whether you could hear me. Go ahead.
No, I could. I just couldn't work my computer, regrettably.
Oh, welcome to the club.
So a few points with respect to Ms. Mulcahy's submissions that I'd like to address. And some are just points of clarification, because if I misspoke, I'd like to correct it. My friend had said that I'd taken the position that I had said that the time to complete an investigative report didn't count in the reasonableness of delay. And if I said that, that wasn't my intention. My friend has spoken about the interviews, and somehow as though when the interviews are done, it's over, the investigation's complete, let's get the report out the door. And you have my submissions on why that's not the case. There's still a lot of work to be done in that, what was done, but I didn't acknowledge or mean to that the time required to produce the report can't be reasonable in any circumstances. I also didn't mean to say, if I did, that resources weren't an issue for us. They were an issue in that this was a large undertaking, and we dedicated the resources we could. Had we had endless resources, perhaps in an ideal world, this may have moved faster than it did. But we did as much as we could with what we had, and we did it in my submission as quickly as we could. With respect to my friend saying that we didn't act with dispatch, on the one hand, there's a complaint we didn't move quickly enough, but then on the other hand, there's a complaint that officers were interviewed too quickly on short notice. And I don't think it's fair to have it both ways. We didn't do any interviews within the first 6 months because we didn't have disclosure until then. The disclosure we received wasn't entirely complete, and it didn't, and I'm not faulting the service for the delay, it's just the inevitability of how you receive a file. And it wasn't always clear which officer did what when we received the disclosure. So some time was taken to decide who did what, to designate officers, and it does matter. They're not just witnesses and interviewed as witnesses. It matters from the officer's position, whether they're being interviewed as a witness officer or a respondent officer, because in one circumstance they have jeopardy. So we have an obligation to the officers from the outset to explain to them what their jeopardy might be in the interview. So the designations are important, and we took some time to do that. But we couldn't have conducted the interviews within the 6 months given the delay we had with the investigator and the unexpected illness at the beginning. With respect to the systemic review, my friend submits that, well, really it answers the misconduct issue. The public interest is met because the systemic review has looked at the DeBungee matter and answers that. And respectfully, that's not the case. The CBC decision that we referred to, the 2019 decision, the divisional court said explicitly there is a strong public interest in seeing that if misconduct is found, those responsible for the misconduct are held to account. So it's not sufficient from a public interest point of view to simply say it was addressed in the systemic. There's very much a public interest in determining whether or not these officers committed misconduct. My friend has also said that we're responsible for the board recusing itself in the first instance because we undertook the systemic review. And respectfully, I don't think that's a fair criticism, especially since we couldn't have known at the time we undertook the systemic review that this would lead to the board's recusal. Had we had some clear signal from the board to say, if you do this, this is the outcome, that would be different. But that wasn't, it was only at the end of the day that the board decided. And we didn't ever acknowledge entirely that it was our fault. As I understand our position in the materials my friend is speaking about, is the board put it forward as their part of their reason for the recusal. But the other factor was that the Ontario Civilian Police Commission was investigating the board. And so they felt, given that they were under investigation at the time and the OCPC had not released its report as yet, that they couldn't hear the matter. And so respectfully, what the board did and why it chose to do so, especially since it's not something we could have foreseen at the outset, I haven't ever seen a board recuse itself. It can't be attributable to the OIPRD delay. And I would comment, we did make the decision to run both concurrently. The conduct investigation was given priority over the systemic review, and that's evidenced by the fact that it was released first. So I don't think it's fair to say that we just ran these both and we didn't care about the time. We did give priority to the conduct, but we did have to do both at the same time. And that's where the resources come in as well. We didn't have the resources to run them independently and concurrently. And part of the reason my friend spoke about the delays in releasing the systemic review, respectfully, it's a bit of a red herring. It really doesn't speak to the attention or the dispatch with which we completed our investigation, but I can indicate that it was due. There were extensive consultations. There were various reasons that contributed to that report being delayed. And I think the important piece to take from that is that our investigative report on the conduct matter was released first. With respect to my friend's submission, that it took us 3 weeks to get the submissions together, I suppose, for the 8317 application, I suppose we could have waited to release the report until we had the submissions. I don't think that is really in the spirit of transparency. We did our best to try to get the submissions done as soon as the report released, and the delay is not such that in my respectful submission, it determines the application. And then if I may just have a moment to see if there's any other comments. Oh, simply on Forstall and the date for the end period. And I apologize, my computer screens are off and I don't have any printed materials and I'm terrified to try to turn one of them on to look at Figueras because I fear I'll lose everybody. But my recollection of Forstall and the issue of pre-charge delay, one, it was under an older section, which was when the chief first became aware of the misconduct. That language has changed when our office came into existence. But the pre-charge delay, I still believe, and I'm always reluctant to say Ms. Mulcahy is misquoting something because she knows the case law better than I ever hoped to, but my understanding is that the pre-charge delay was up until the chief brought the application, but he was aware of it for some time prior to that. So that's different than saying that once Ms. Walborn on behalf of the service brought the application, that all that time up until the first date should count, because I don't think Forstall speaks to the delay post-filing of the 8317 application until the hearing. I think it speaks to something else, but I stand to be corrected and I apologize that I can't confirm that for you. And I think, subject to any questions you may have, those are my submissions in reply.
No, thank you very much.
Thank you.
We'll go to Mr. Faulkner. And
Mr. Ferrier, Ms. Churchill will commence the reply with replying on some issues of law, and then I'll close out, all in our 15 minutes.
All right, fine. I don't see her on the screen.
I am right here.
Oh, there she is. I beg your pardon.
Perfect.
I'm sorry.
That's all right.
That was my fault.
You're probably looking for my colleague in Thunder Bay. And that can't be seen right now.
Okay.
I'd like to take this opportunity just to address two quick points, specifically on the case law raised by Ms. Mulcahy's submissions. The first is Ms. Mulcahy referred to the legislative purpose of Section 8317 and the purpose of expediting investigations into misconduct. And in our submissions, it's important to understand that purpose within the broader purpose of the Police Services Act as a whole. Now, are you able, I'm not sure what you have access to, but the Court of Appeals decision in CBC and Ferrier,
Yeah,
sorry.
I've got it.
So if I could take you to paragraph 72 of that decision.
Just bear with me.
It's on page 30 of the case, I believe.
Sorry, what paragraph?
Paragraph 72.
I've got it.
Okay. So in this paragraph, the Court of Appeal quotes with approval from another case that's in the Book of Authorities before you, Figueres. And the Court of Appeal says the purpose of the Police Services Act has been judicially described as being, quote, to enhance public confidence in policing by ensuring a more transparent and independent process for dealing with complaints against the police, end quote. So that is one of the purposes of the Police Services Act as a whole. The court continues saying that the statutory framework was, quote, designed to increase the transparency of and accountability for the way in which the conduct of the police is dealt with, end quote. So understood that way, the purpose of expediting an investigation into misconduct is certainly tied to this broader purpose underlying the Police Services Act of the importance of transparency and accountability in dealing with police conduct and police misconduct. So that was the first point I wanted to make. The second, Ms. Mulcahy referred to paragraph 84 of the Divisional Court of, I was going to pronounce it Forstall, but I heard Ms. Mulcahy pronounce it Forstall, so I will adopt that. And that case, it's found at tab 4 of our Book of Authorities. And I would ask if you're able to pull up paragraph 84 of that case, Forstall and Toronto Police Services Board. And it's tab 4 of our Book of Authorities.
Oh. I'm sorry, which case is it you're referring to?
This is Forstall. I believe it's actually in a few different briefs of authorities before you.
Yeah, I can't find it in yours, but just a second. paragraph 84.
Yes, please.
Yes, go ahead.
So in that, the court says subsection 6918, which is now 8317, directs the board to form an opinion whether in the circumstances it was reasonable for the chief to delay serving the notices of hearing. In coming to its opinion on this limited issue, it is for the board to decide how much weight to give to the relevant factors. And it's this next sentence that I want to highlight because I think is important, very important for the decision before you. It was for the board to evaluate the complexity of the investigation, the potential prejudice to the applicants, and the public interest in seeing serious police misconduct adjudicated, among other factors. So I just wanted to highlight there that that factor of the public interest in seeing serious police misconduct adjudicated is a factor that is there for you to consider. Mr. Falconer has gone through in great detail the public interest, in this case in particular, of having the police misconduct adjudicated. So I just wanted, in response to Ms. Mulcahy flagging that paragraph, I wanted to draw your attention to that point. And that concludes my portion of the reply, and I'll hand it over to Mr. Falconer.
Thank you.
First of all, Mr. Ferrier, briefly, we should have addressed your question in our main submission, and I meant no disrespect. It's my oversight. My simple answer is I think that you do have to take into account the Oiprd time with the matter.
I don't have any problem with that position, frankly. The wording of the legislation is really unfortunate.
That's right.
And I won't use any stronger language than that. But I think to interpret it otherwise would be a difficult task. But anyway, go ahead, Mr. Falconer.
That's right.
Thank you for that, though.
And there is practically speaking, it is important that the legislation is interpreted that way, because when complainants, as in this case, ask the Oiprd to retain the investigation, it can't work to the prejudice of the responding officers or anybody else. It has to be a situation where they step in the shoes of the investigating, whether it's the actual department, Thunder Bay Police Service, or another one. And so they're stepping into those shoes, and I think we have to interpret it that way.
Thank you.
I want to deal very quickly with the suggestion by Ms. Mulcahy that the systemic review was something that was optional for the Oiprd and her submissions that flowed from that. I can't emphasize enough respectfully how cynical a submission that is. The findings make it clear that it wasn't optional. Findings make it clear that there is an extraordinarily damning indictment of the Thunder Bay Police that has occurred here on a systemic level. And so any doubt as to how important and imperative that was has been cleared up by what that report has done. And by the way, not a single submission by any of the parties in this proceeding as to the invalidity of the systemic review. That is, you didn't hear from them that it was suspect in approach. You didn't hear from them that the analysis was flawed. Didn't hear any of that. And the reason you don't hear any of that is because that systemic review stands as a very credible piece of work. So saying now that given the level of systemic racism at an institutional level that was found in that report, that was optional, you could have just left that unaddressed. In my submission, clearly the decision was a good one. And when you're weighing public interest, which is really where I'm going now, you ought to take into account how that imperative ultimately was justified. Finally, I want to address this notion that you should participate in this sort of, you should roll up your sleeves and do a numbers accounting job. We're going to add these days, we're going to take away these days. At one point, Mr. Mulcahy referred to the fact that it took the First Nations complainants 30 days to develop a position on the board, abdicating its role to make a decision. Something the OIPRD director observed, and you'll recall this quote in the report, that Mr. McNeely was the first director of the OIPRD. Its inception date was 2009. So in the whole history of the work of the OIPRD, they have never seen a board take that position. So forgive me if Rainy River First Nations and the DeBungee family had to be consulted, mull over the issues, and took some weeks to respond to an extraordinary development, which was the board walking off its job. I understand, and Ms. Mulcahy points to the Court of Appeal not having a problem with it. I remain of the view that that notion of MIA is seen there. But what I want to emphasize is that it's not a mechanical exercise of you tallying up the days. That isn't how this should be determined. And the case law is clear on this. So this a mechanistic approach has a real risk of resulting in injustice. The public interest is weighed on what I would say a far more nuanced level, a more holistic level. You look at the nature of the case, you look at what's at stake, and you make a call. And that isn't a ledger piece. I'll add these weeks and these months and come up with these days, and some of that's their fault and some of that's not the exercise. And there's a lot more flexibility read into this. And I say the flexibility that is read into it is a function of the importance of you putting the appropriate weight on public interest. So in my submission, once you do that, the public interest in ensuring accountability in respect of these massive investigative failings in respect of a death needs to go forward and shouldn't stop at this point. That wraps up our submissions, Mr. Ferrier.
Thank you. That then completes the matter. Thank you all for your assistance. I'll have a decision as soon as I can reasonably do it. Thank you. I think we're done.
Thank you.